That's the problem for here, you know, what I need to keep. Not very well, but probably good. Good table and the two money. So if there is something I felt that's happening about government students. Thank you. Tax one. Yes, on the 80. People.
Hello, good afternoon, everyone. Welcome to panel 22. Just a quick check, because there are some other panels happening at the same time. This is the one on AI regulation and international economic law. So if you are looking for something else, you still have the time to get the right place. Okay. However, if you are in the right room, it's great because our topic really sits the crossroads of emerging technologies, trade law, and global governance. And honestly, this day when people come to LLM, half of the time they are talking about large language model instead of master of laws. So yes, artificial intelligence and the question of how to government it is obviously one of the most popular issues right now. So let's dive in. My name is Claire Liu. I'm a lawyer at Chen Chang Attorneys at Law here in Taipei, and I'm very happy to be your moderator today. We are very lucky to have three distinguished speakers joining us. They are going to share their insights on how AI is reshaping the legal, institutional, and economic framework that support global trade. And their perspectives span from different jurisdictions and disciplines. So it will make today's panel a truly global conversation. Please join me in welcoming Professor Anthony Abad from Ateneo de Manila University. He specializes in international trade law and advises on trade policy and regulation. And Professor Rostam Neuwirth from the University of Macau. He specializes in international trade law, applied philosophy, and legal oxymoron. And Dr. Marta Soprana from LSE Ideas specializes in digital trade, services, and global trade governance. Thank you all for being here. And let me briefly explain the timetable for today's panel. Each of our speakers will spend around 20 minutes to share their views. And after that, we'll move into about 30 minutes Q&A section for audience questions and more discussion, and including the chance for our speakers to respond to each other's ideas. I encourage everyone here to note any questions and reflections you'd like to share during the Q&A section. So now our first speaker is Professor Anthony Abad. He will explore how AI is challenging the WTO's traditional tariff-based framework and consider whether other legal approaches, such as competition law, might help us better manage its impact on international trade. Let's welcome Professor Abad.
Hello. Okay. Good afternoon, everyone. Thank you, Claire. My name is Tony Abad, a professor of international economic law, but I also teach competition law at the Ateneo de Manila University in the Philippines. I am also a back to school student. I am a PhD candidate researcher at the World Trade Institute now. And I'm actually going to be talking about my proposed research, which I have just started out with. And I know it's been asked, why now? Why are you taking your PhD at this stage of life? Senior citizen PhD. I explained that part of it is the pandemic. I just needed to do something. And also that one of the challenges I had to face was really that I had not really written anything. All my crazy ideas were just stuck here in my head. And I thought that doing this PhD, doing this dissertation would be a way of putting in writing and publishing my thoughts. And finally, perhaps the most important part is it's part of an advocacy, something that I've always wanted to promote and push. And it is really going back to the concept of the interface or the intersection of international trade and competition. And it just happens that because AI is now presenting a very interesting case for the return to the discussion of trade and competition. I recall that in 1996, it was one of the Singapore issues, trade and competition, but then died a quiet death in 2004 when they canceled or they removed the working group on trade and competition. So there not that much material really on the specifics of how you're going to operationalize trade and competition is probably one of the challenges or one of the problems that that led to the demise of the issue. So I'm going to talk about how AI transforms international trade, and that as a lawyer, as a professor of international economic law, and as a competition advocate, a competition law professor as well, that I could see that it's going to transform trade in a way that you have to question the existing legal framework for international trade and competition. So that's what I'm going to be talking about. I'll try to keep it short, simple, not so formal, and hopefully there's more time for questions and discussion later on. So the crazy idea, the theory on the transformation of international trade in the age of AI, and that there is a need for a new legal framework. Not incremental, but really a real new legal framework. So we have to look foundationally and fundamentally at how we regulate international trade, and that's what I'm going to be researching on. I am just at the beginning, year 2 of this dissertation. So in terms of the research, I'm just beginning. I decided, okay, I'll present this year, even if the study is just beginning, because I realize that the more I talk about it, the more I share these ideas, the more feedback I get, more comments, more maybe people will be a little skeptical, but once in a while, I'll find the rare gem of a collaborator or an ally in promoting this. So essentially, the research is on AI, trade, competition, artificial intelligence, and the future of the international trading system, rethinking the old tariff system and trade regulation based on border control, and developing a new legal framework for international trade based on competition policy and law. Explain that in a bit. So the research begins with looking at how AI applications operate in international trade. And we'll find out how extensive the use of AI is currently in international trade, and there's a very big implication for this. Well, part of it is that it accelerates economic integration. So what we were all dreaming of when we first came up with the GATT and the WTO, which is really an integrated world trading system, might actually come true, but not because of us, but because of AI. And that will make us rethink what the legal framework for international trade is, and finally, to look or revisit competition policy and law to, at the very least, use the principles of competition policy and law to establish a new legal framework for regulating international trade in this new AI-driven or AI-enabled international trading system. So very quickly, this is not exhaustive. These are just examples of how AI is used in international trade. The most obvious one would be the physical movement of goods, the supply chain management, autonomous ships. These are things that are already on the horizon. Warehouses that are also autonomous, and we see that already. Amazon and Alibaba both have robotic warehouses. So AI extensively used already in their logistics. Trucking, trains, planes, all of that is now driven at the very least by algorithms and programs that ensure that there's an efficient movement of goods. Trade data analysis is a very big factor here. Because of AI, you're able to manage an amount of data which is humanly, we thought was humanly impossible to manage. So the data is, I don't know, it's going already up to the million times that the human would be capable of analyzing and storing and using for implementation in trade. Trade facilitations also subject of AI. The clearances, the movement across borders have already been automated in many parts of the world. But not all, of course. There are still places where customs officials would prefer to be doing it themselves. Trade regulation compliance also inputted into programs for compliance, and this speeds up the process, the approval process for the trade. So any particular trade of goods can be already approved beforehand with the help of AI. Trade finance, also very important factor. How do you finance? How do you source the expenses for trade? And this is also plugged into the system. And of course, financial AI is also a big factor. So banking and finance itself as a sector is already growing exponentially in terms of the use of AI. And part of it will certainly affect trade finance. And with data, with big data being now accessible and manageable because of AI, you have a better sense of market intelligence. So decisions with regard to trade are accelerated exponentially. And then language translation. Okay, now there's LLM, okay, that Claire mentioned, but also there's literal language translation. The direct language translation also has shown that there is, at the very least, the studies show there's a 30% increase in the volume of trade just by using a translator. But I think it's probably much higher by now. So these are just examples of how AI is used in international trade. It is accelerating the process of regional and economic integration, how it's moving things faster and faster. If you apply Moore's law, computing capacity increases doubles, the capacity doubles within an 18-month or 2-year 18-month to 2-year period. That means any computing that's being done now, after 18 months or after 2 years, it'll double. Okay, so just imagine, and then that amount, that volume will double. So that's how it's why when we call it exponential growth, it means that it is increasing almost, again, in a humanly, it's very hard to imagine from a human's point of view. Okay. That means that relevant markets will now be defined in bigger scope, bigger footprints. And this is where you have to understand, and this is part of the study, is trying to understand the nature of AI itself. That AI is a tool, okay? We're not yet at the point where it's going to take over with the Terminator and the Matrix. But short of that, it is a tool purely for the purpose of achieving efficiency. And AI's main purpose is achieving efficiency. So it's always looking for efficiency. And it doesn't look at things like the politics, doesn't look at trying to protect domestic industry or trying to protect sovereignty and all that. No. AI just needs to do its prime objective, which is to deliver goods in the most efficient way possible. With that efficiency goal, I see a phenomenon which I would call systems integration. That AI will seek out or will seek to integrate with other AI systems. And that phenomenon will lead to a bigger and bigger footprint for particular products and services. Okay. The other thing is that now you have to rethink the way we regulate international trade. Now, historically, we have tariffs. And tariffs are basically, it's just a form of tax, okay? An external tax collected at the border, either ad valorem or specific. And it has evolved over time as a form of gatekeeping device, okay? Or it is the right of a sovereign state or sovereign economy to protect its economy by using the tariff. So eventually, by the time of the GATT, we tend to look at tariffs not just as a tax, but really as a way of regulating the flow of trade. But the raison, or the reason why you do this, is you're trying to protect your domestic industry. And that means that your domestic industry, that market, is separate from other markets, which is now coming into conflict with the concept of the systems integration of AI, which is forming a bigger and bigger integrated market. So imagine the world getting eventually all integrated because of AI. If you allow AI to take its course, you allow the capacity to increase exponentially, you will eventually see this happening. And then other issues in regulation, such as classification, okay, of products. So when we look at products, again, the term product, we have to be clear, it's not just about goods, but also goods and services. And when a product is AI enabled, as a product, the physical product that is AI enabled, is it the AI that you're selling or is it the good? Because the good, for most AI enabled products, will be useless without the AI. So what is the business model here? And that means it becomes a challenge for the old system of classification, valuation, and nomenclature, and the application of tariffs when you're trying to protect domestic industry and AI is actually trying to bridge or try to going across all these borders. So actually it is coming up with a de facto and virtual borderless world. In a borderless world, I know in an earlier panel, there is the issue that, well, there is a digital divide. liberalizing economies does not necessarily lead to equalization, equity, or the development of less developed areas. So how do you make sure that there is integrity in the markets that are created by AI? And that's what takes me to my other favorite subject, which is competition policy and law. Okay. I know that I get certain certain reactions, especially for those who don't think that the two communities should get together, the trade community and the competition community. But I happen to be one of the few people who's teaching both and appreciate both. I spent a good amount of years in the 90s as a tariff commissioner in the Philippines and applying, not just applying tariffs, but implementing anti-dumping measures and safeguard and countervailing measures. And as a competition lawyer, I sort of felt uneasy about some of the cases that we were handling. We would follow the law to the letter and apply the anti-dumping duty, but I knew that I was protecting an industry or a firm that would otherwise be considered as a dominant firm. So was I actually making it worse for the Philippine market by protecting this local firm or local industry? And the same thing went when I was a panelist for the rules division. Most of my panels were for the rules division at the WTO. And again, without looking at the market implication, but without looking at the real market system analysis, I would just apply the law, apply the agreements, and apply WTO law as we see. So that's made me think a lot about how the future of international economic law will now look with this scenario. And I think it's my last slide. Okay. So I'll leave it at that and be open to questions in a while. Thank you.
And next we have Professor Rostam Neuwirth. He will look at AI through WTO law, exploring AI's complex and cross-border nature and the challenges this creates for today's trade law. He'll also consider how past debates about linking trade and border policy goals might help us think about the future of regulating new technologies. Thank you.
Thank you very much. Hello. Yeah. Thank you very much for the kind introduction, especially for my reference to my LinkedIn profile and applied philosophy, which already gives away why I'm actually interested in AI, because it's an oxymoron. And I actually have been studying AI now for, well, when the hype started in a way with the EU releasing the draft AI Act. And I've frequently changed my mind about it. And I have so actually last night, which is why today I still changed my slides. And I actually also changed them just before in the panel. I was very much intrigued by the panel you just, Colin in the back, just gave. And I would have liked to ask questions there too about career questions of and how to think about the future also of not only the careers, but how to contribute to this system. And I've been studying WTO law now exactly 20 years, and a few days ago I defended my PhD in the... okay. Okay, thank you. So I've been studying culture and trade at the time, and I encountered at that time also a notion which was then used first by philosophers, actually. The Frankfurt School used to coin the concept of culture industry, which I then traced back to the Frankfurt School because I found it at the time studying in Canada the US-Canada free trade agreement. And there it was for the first time used as a legal term. And it is considered an oxymoron as well. And then I looked around ever since, trying to find a solution how to reconcile culture with trade. And so I looked at culture, trade and health, and trade and security, and trade and issues, and the whole trade linkage debate. And wherever I looked, I found oxymoron. And then I thought, if you find something frequently, it becomes a pattern, and there must be an underlying problem to that. And I feel very much like you just mentioned, in a way, the problem rests within the system and the architecture and the structure. But where does that actually come from? It comes from a deeper layer. It comes from the human mind, I think, because this is what established these structures. And the latest one, the latest addition in a way to this catalog of rising number of oxymora is in fact AI. And I don't think it's a coincidence that AI is a technology that is trying to replicate artificially the human mind. So I think here we see a circle closing, that things started from the mind and now we recreate it artificially to identify the problems. And that's why I think AI is in fact a total misnomer in many ways, and it is not something intelligent at all. I think it's a technology, and it should be treated as such and not as some intelligence, especially when nobody knows what human intelligence is. So we refer to some standard we do not understand, the human form of intelligence, to apply it to a technology. How can we then measure it? And I'm saying that because I've seen a lot of graphs saying AI, like Moore's law, is going to exponentially increase and become super intelligent and much smarter than us and replace us. And then the same graphs very often show human intelligence is a flat line. So I think this is a complete misperception, and I look forward to your presentation later on, because you talk about the Brussels effect and the Singapore effect, and I think it's the Silicon Valley effect in many ways also that makes us believe that this is so much smarter than us, because you want to sell it. But it has nothing to do with actually what it means in the long-term perspective of humans' evolution, humanity's evolution. So I want to come back and briefly share with you some of the observations from the last 20 years in many ways. And I think that AI is just another link in a longer chain, and it is a chain of missed opportunities. And we are paying the price for it. And as long as we are not going to address it at the core of the problem is going to increase. At least that's my personal experience. When you avoid problems, they become like an avalanche, a snowball effect. And until one day you have to face it because it all crumbles in front of you. And that's also a bit the history, I think, of our international legal system. And the summit of the future just held last year, ironically, it was much less paid attention to in the media, but it is really, I think, it also includes a global digital impact, and I think it should have received much more attention than it actually has. But it says we need to understand the interconnectedness of past, present, and future. And I think this is a very important question we can maybe discuss later, because I have also published something on what I call four-dimensional thinking now. But basically, how did we get there? Already in 1995, the year actually the WTO was established, two scholars, James Rosenau and Charles Handy, probably not talking to each other, had the same, in a way, idea or the same vision about the 21st century, namely that it is the age of paradoxes, and paradoxes are the cousins of oxymora, so it's the same. And in fact, Rosenau even said it, the 21st century means to discern powerful tensions, profound contradictions, and perplexing paradoxes. And I think it has really come true. And you also mentioned the acceleration. This is also another synonym for the Anthropocene, which is another paradox that we are now living in a time where humans are apparently the most dominant force on the planet, which would mean that all the problems which we have actually caused should be easily solved. Because if we are the dominant force and we created them, well, then it's not something we look at as force majeure, no? It is something we can fix quickly. And there, in this regard, I came across a very good quote from a book by Gordon Allport, published in the 1950s, where he said there is a big gap in the mastery of humans over machines and over nature compared to the mastery of our own human nature and human relations. And I think this is a gap that is still widening. And I see a danger if we further emphasize the need to develop AI as a technology and not foster human intelligence, that gap is going to grow wider and the catastrophe that will follow is going to be even bigger. And there have been plenty of warnings over the last 20 years about this widening gap between and this tendency to think in terms of it's either this or that, and not it is a both and approach like trade, and it's called the trade linkage debate, not the trade separation debate. Unfortunately, I still see so many of these terms being applied, like non-trade concerns, a total misnomer if you ask me, because everything can be related to trade and is related to trade. Another term that shocks me every time is the dichotomy of developing and developed countries. This was one of the articles it took me the longest to publish, which was about abandoning this dichotomy, because dichotomies are false dichotomies. Especially one if you kind of contrast an adjective with a verb, because one is a state of being something and one is an active, a verb of becoming something. So you can't even linguistically use it as a dichotomy. Apart from that, dichotomies simplify things and make it seem easier than it is. So I think the trade linkage debate has already 25 years ago, and even earlier, actually, I think it started with the failure of the International Trade Organization, that trade was somehow not included in the UN system. We have this gap between trade and other public policy goals. And ever since that, we perceive them as separate. And I just want to show a few things. I criticize that in many of my writings. It has also been recognized with what it is concerned about. And I think we have seen the global pandemic in particular was a case where you could see that a non-trade issue, like a disease, a pandemic, a health issue, is very much related to trade and to everything else. I think the global pandemic was this wake-up warning call for all of us, because we were restricted in time and in space for the first time in a way in a global event. And it showed very much like what David Held wrote. He said, this is the paradox of the world today, that we have more and more global issues, but the way we address them is local, weak, and incomplete. And I think this is a serious matter. And there's also another very good book I found by Valentin Reutner, already 2017, I think, which uses another oxymoron, irresolvable norm conflicts in a way, and he mentions the term of a legal dilemma. So also in the kind of oxymoron and how to deal with that. So the underlying issue in my view is we haven't learned how to think beyond dualistic reasoning. I'm not saying that dualistic reasoning and dichotomies are bad. They're just not the end of the story. And when you look at these examples, you see this thinking repeated over and over in different areas. IP law, another oxymoron, by the way, is split still today in these two conventions. One is basically dealing with the commercial aspects, patents, trademarks, and the other one, the artistic or cultural ones, copyright. The same is true with even new media. For example, when films and TV was developed, people said, well, this can be used for education. We can teach and we can enrich our lives. And others said, well, we have to be careful because it can also used, and it was used also for the cause of war and still being used for that. So I don't think it's the best way to approach an issue by trying to split it. And we see the same today. AI for good. How are we going to achieve that? I think it's naive. It's an oxymoron. It's both. And even the UNESCO recommendation says it has positive and negative impacts. And unfortunately, it will have them simultaneously in everywhere, ubiquitously. So I think this thinking, the most ironic one is probably the field of human rights law, which says they are indivisible, and then you divide it into covenants. So I think this is the ultimate problem. And this is a problem that is still perpetuated also in the way we regulate. For example, I looked at trade and problems how they have been for 2,000 years, since the Romans. The Romans had a law where they said some goods are exempted from trade because they are different, like cultural products. And that is still reflected in Article 20, even though the UNESCO Convention, maybe the EU Treaty after Maastricht, they tried to change the language from a negative approach to a positive approach, an integration clause to enhance the coherence. I think the thinking is still very much either or. And in this respect, I'm afraid that the book edited together with Colin also and others who are here has become a reality, in fact. No, just in 5 years, right? And that is, on the other hand, very much encouraging, because we live now in the time of acceleration and in a time where differences disappear. And the increasing uncertainty has for a long time been perceived by myself too as a kind of threat. It's uncertain. On the other hand, I remember a time where my life seemed to be much slower and much more certain. But then it was also like a bit being imprisoned, because whatever you tried, you couldn't get out. You couldn't change it. Nowadays, I believe we are entering a new age where uncertainty can be turned into possibility. And that, I think, is what AI really is. It's an opportunity to turn this uncertainty into a new kind of possibility. But to that end, we also need to know what we want to achieve. And that is at the moment, I think, the hardest to achieve, because I think it is almost like a runaway train, and we follow the old path without thinking of where we are going. And here I just want to say a few things about digital technologies. It's not AI that started it. It's digital technologies. And before that, there was something, there were always, it's a line, a continuous line of technological innovation, which poses, in fact, new challenges. And we don't have to go far back, but I think digitization is very good, simply because it shows that this kind of thinking of either or is outdated. And particular digital trade here, this I like this a lot, means that goods can be like sold in physical and in digital formats. And what the system cannot achieve is that we can, or what we cannot achieve with this kind of thinking, is to actually perceive these products as both physically and virtually traded products at the same time. And that doesn't fit into the system. And on top of it, I will also try to show that the same applies to AI in the field of intellectual property law, that it's not that generative AI is going to revolutionize or to threaten IP law, because IP law didn't work already the last 20 years properly. It's just another sign that we didn't learn the lessons from the last 20 years or more, or 80 years, if you want even. So let me show you, when it comes to AI and LLMs, for example, the main issue is also that there is this fragmentation still prevalent in the way we approach it. Like you just said, you hardly dare to bring trade and competition lawyers together. But it was in the Havana Charter. It was foreseen to have a chapter on competition law in the trade chapter, or combined, right? And today it's the same. There's this simplification, like that the EU is actually talking about protecting the citizens, but the AI Act is not a human rights instrument at all. It's for the common market, the internal market, to make sure there's not going to be too much discrepancy. So I think we have to completely stop thinking across the existing categories. And that is in particular true with regard to the classification list of the services, which is outdated. It's from 1991. In my view, what you just shown also is like that some AI products or services or whatever you call it is fitting all these categories. You can ask legal questions, health questions, you can ask to design something, to plan your home, etc., etc. So it does not easy. I think the WTO report issued last year says basically the most relevant would be computer services, but I think that's a simple way out of the question. It's far more complex than that. I just want to give a few examples, like, there is already 3D printing is already being basically possible. And it's apparently also existing in terms of 4D printing, which is really interesting, which is what I want to conclude with. What is four-dimensional thinking? That you integrate the time factor into it. And it's a technology which allows you basically to print a product, and then the product may change the shape over time. So maybe in the future you can download a file from IKEA in Sweden and then print your shelf at home, and it assembles itself. Basically, that's what I understood what the four-dimensional version of it be, namely that you consider the development over time. And that, I think, is very important. Before I get to that, just want to say IP law. I have just published an article on that. I think IP law has failed completely to address one major issue, which is how the future of work should look like. I think IP law has a great opportunities positioned very well to rethink the idea of labor. Maybe we can give up that term and find something else. I like being creative, for example, but being remunerated in a fair way is very important. I just want to mention one thing. I was shocked when I saw this, the Guardian issuing reporting about Amazon's self-publishing platform, that since AI, they restricted it to publishing 3 books a day. And I think all of us have most likely written a thesis or something. Writing a thesis in a year is hard, let alone 3 in a day. But it's a possibility. And the problem, though, is that remuneration is becoming worse and worse. I think, and this is also something what is striking me when I look at early career colleagues, my PhD students, for example. We just heard that many are on one-year contracts from 1 year to the next. I think not being remunerated for creative work was fine when you had a decent salary, because then you could say you receive a salary and you contribute to society. But when you have neither a salary nor fair remuneration, namely you do 95% of the work and you receive 5% of the royalties, maybe, that's not fair and that's not working. And that's a problem that is and has not been addressed properly by competition law over the last 80 years, in my view. There was an important case by the US Supreme Court about cinema in the 1940s. But ever since, there are anti-competitive practices in all sectors. It's not just cinema or soccer, it's academia, it's anywhere you look. So because of this background of the threat of AI threatening our jobs, I want to conclude to say that we simply need to adapt to the current realities that we have, in fact, neglected for too long. And I think we should take a step back and rather critically challenge how we think about the different phenomena, and not just insist on interpreting Article 20 again and again. What does it mean? I'm tired of it, honestly, in many ways, because I don't want to discuss certain things anymore from that angle. I think we need to look at ourselves critically. How does our patterns of thinking perpetuate these obsolete structures? And I came across that the most in the context of the institutional debate about AI governance. I found 2 proposals saying basically we need an AI WTO, modeled after actually the Atomic Energy Organization. Another one was a bit more creative and said we need, because we have more stakeholders, we need an ICANN kind of model. And I think both is useless. We will add something to an outdated system, which would make it even slower, more ineffective, more unnecessarily duplicating each other, and that would not improve anything. And then I tried to look at how can we propose something new? And it's really hard to think outside the box when you try. But I came across a notion, 4-dimension. The 4th dimension is a really interesting concept because I came across it based on Albert Einstein. He said, well, Isaac Newton, absolute space and time is no longer valid. Minkowski actually wrote it beautifully down and said from now on, we have to think as space and time as a continuum, a 4-dimensional continuum, that we have 3 dimensions of space and 1 dimension of time. And I think when we look back at that, that's 120 years ago, more or less, that these ideas were formulated, and we haven't yet integrated in our legal thinking in particular, not even in thinking. But I looked at the Black's Law Dictionary that the definition of time is without reference to space. And I believe that that's my take on the global pandemic recently. I think it was a kind of initiation to space-time reality, because we had already conquered space by the transport and communication revolution, but we have not yet conquered time. And time, I think, is crucial with regard to space and with regard to planning the future in particular, because it will determine how we plan and how we connect the past to the future. And in fact, Carlo Rovelli, a physicist, he said that the language that we apply to the complexity of time or space-time is inadequate. I wrote him an email and asked him, should we apply oxymoron and paradoxes? But I got an automated email that he's very busy. So I have no answer to that. But I thank you very much, and I hope we can also discuss more. Thank you.
Wait. Okay. Let's welcome our final speaker, Dr. Marta Soprana, and she will compare two constructing models for AI governments. It's the EU's binding regulatory approach and the Singapore's soft law strategy, and explore their trade implications and potential for global trade. Thank you.
Thank you very much. I would like to start by saying that I started my research on the nexus between artificial intelligence and international economic law before everyone knew what ChatGPT was, and that was in 2018. And I arrived at artificial intelligence because a lot of the conversation happening at the time related to the regulation of digital trade surrounded in particular cross-border data flows. And in my research, I realized that why was data so important? Why everyone was really concerned so much about data flowing freely across borders, or ensuring that it will flow freely. And I realized that one of the technologies that really requires data to travel freely across borders is artificial intelligence. And that's how I ended up sort of a little bit into the rabbit hole of artificial intelligence. Now, what I'm trying to discuss today is one aspect that I think is very important for us to remember, that the way government regulate artificial intelligence matters for international trade law. And this is because I've noticed that while the conversation up until the mid-2010 in digital trade regulation was very much focused on data policies, from the mid-2010, something happened because governments started to recognize the opportunities and the risks arising from the use and development of artificial intelligence. And this is because way before sort of ChatGPT kind of like showed the world what AI could actually do, or that particular type of AI, something was happening in the field because of increased computing power, because of breakthroughs in theoretical understanding of AI, and of course, because the more we use the internet, the more we generate data, and therefore now the models and the AI systems could actually be trained and be more accurate because they had more data that they could access. Possibly good data, which is another thing altogether. So what happens is that governments around the mid-2010s recognized the need to capitalize on the opportunities that artificial intelligence offers, but at the same time, they became concerned about some of the risks associated with AI. Some of the risks concerning, for example, privacy apply to every digital technology. But there are certain risks that are specific to artificial intelligence, such as the so-called black box issue, the opacity, the fact that artificial intelligence, if well developed, is able to find patterns in a huge amount of data that humans cannot find. And therefore, the outputs that the AI systems produce we might not be able to understand why they came up with that specific recommendation, with that specific prediction, for example. Now, governments responded to AI in very different ways. Now, let me clarify one thing. AI, compared to other emerging technologies, is not emerging. It's not a new technology. It dates back to the 1950s. But what is emerging is the fact that it is only now, basically since the development of artificial neural network and the use of basically deep learning AI systems, that we can actually have finally commercialized, viable products and services that are powered by artificial intelligence. When the WTO was founded in 1995, they had attempted between the late 1980s and early 1990s to develop certain commercial applications of AI using expert system. So before machine learning, before deep learning, it didn't go well. It didn't go well. They were not really viable. But now we live in a world where we have AI applications that are widely commercialized. So governments understood that this can be capitalized. And so we find in a situation where everyone started responding differently. We do not have a uniform response to this AI spring. And at the moment, we know that governments are engaged in what we will call an AI race, an AI battle, because everyone is attempting to either become a leader in AI or in other ways to capitalize, build the capacity in AI. So a lot of attention has been clearly goes to the AI superpowers, China and the United States, because these are the countries where you have the tech giants that are developing the technology. But what I've noticed in my studies is that there are a couple of countries that are actually at the forefront of AI governance or AI regulation. What do these two countries have in common? They are open economies. They have high AI capabilities. And they do not have native companies that are a comparable size to the US and Chinese tech corporations. And these two entities are the European Union and Singapore. But the approaches that the European Union and Singapore took to the regulation of artificial intelligence differ massively. The European Union went the hard law route. Singapore went the soft law route. But the two approaches matter for international trade law because if the world follows into the European Union footsteps, we find ourselves with binding regulations, comprehensive regulations on AI that may actually create new barriers to trade that might become in violation of existing rules enshrined in the WTO agreements and even in digital economy agreements. On the other hand, if we follow the Singapore approach, maybe it is a little bit more friendly, but it doesn't have that much bite. Now, in what ways do the two approaches differ? So the European Union is the first country in the world that in 2024 adopted the first comprehensive AI regulation, so horizontal, it applies to all sectors, and it is risk-based. What it does is they classify AI systems based on their level of risk. And one of the key points of that regulation is that it includes a prohibition on deploying into the EU market certain AI systems that the European Union thinks pose an unacceptable risk, meaning that that is actually a barrier to trade. You're basically banning certain AI systems, so certain products and services that use those systems from entering the European Union. So this is a domestic regulation that has extraterritorial reach. It applies to all suppliers of AI systems as long as they intend to supply their services and products in the European Union. One other aspect, the European Union, when they negotiated the GDPR, they also designed potential horizontal provisions in international trade agreement that reflected sort of the GDPR. So the idea of we will allow the cross-border data flows, but they have sort of but exceptions that reflect sort of what is written in the GDPR. So protection of personal data. There is nothing at the moment that reflects in the agreements that the European Union is signing. There is no artificial intelligence provision in its agreements yet. Singapore has taken a different route. Singapore doesn't have a horizontal AI regulation. Everything is much more soft. They have a national AI strategy that provides a vision of what the Singaporean government wants to do with AI. They have, but it's the first country in the world to do two things. One, at domestic level, they developed the Model AI Governance Framework, which is a guidance for private operators on how to develop ethical AI, but it's a guidance, it's voluntary. They have updated also that model to include also a model for generative AI to respond to clearly some of the issues related to generative AI. The second part, which is relevant for us, is that Singapore is the country that drove the conversation about negotiating in its new digital economy agreement, a provision that is specifically and explicitly dedicated to artificial intelligence. That is, the first was Article 8.2 in DEPA. And then subsequently, they included also in the agreement with Australia, with South Korea, and the UK. So this got me thinking. First of all, are any of these models diffusing? So do we see other countries adopting similar approaches? Second, what are the factors that may influence whether a country is going to follow in the footsteps of the European Union or Singapore? And the third question clearly is, if any of these two models is going to prevail, what does this mean for international trade law moving forward? For example, can we think about maybe a hybrid model that takes advantage of maybe some of the strength factors in one model and maybe the same in the other model? So what I found in my analysis, responding to the first question, so are they diffusing? Now, let me say this. Singapore adopted the first provision in 2020. And the model governance framework dates back also to around the same time, 2019, 2020. The European Union, the first proposal dates back to 2021, and the EUA Act was formally adopted last year. So we're talking about 5 years. So there isn't necessarily a lot of data that we can rely on, but based on anecdotal evidence, we can start to see something. What we can see is that with regards to the European Union, we see a relatively limited Brussels effect. When I talk about this, I'm talking about a de jure Brussels effect, meaning are there other countries that have adopted a regulation that is similar to the one of the European Union? At the moment, there are 2 countries that have adopted formally a comprehensive AI regulation. One is South Korea and one is Japan. But South Korea, the South Korea approach doesn't have any ban on specific AI systems. And Japan, it's not even extraterritorial, doesn't have any classification of AI systems based on risks. So they use the EU as a blueprint, but they have shaped very different approaches from that. Other countries that had expressed an interest haven't gone much further. China and Canada so far have abandoned their proposals for a comprehensive AI regulation. Brazil is still negotiating the proposal. Now, what about Singapore? What I've noticed is that taking aside the other digital economy agreements that Singapore has signed with other countries, we have 6 agreements where Singapore is not a party to, where we find an AI-specific provision. 3 have been signed by the United Arab Emirates, with Turkey, Georgia, and Australia. And 3 have been signed by the UK, with Australia, New Zealand, and Ukraine. What is interesting is that the one signed by the UK, actually the provision is about artificial intelligence and emerging technologies, whereas those signed by the The United Arab Emirates, I'm sorry, jet lag is kicking in. These are really very similar to the initial proposal of the first two agreements signed by Singapore with that specific provision. Now, clearly, we know from past experiences as well that countries sometimes they do copy and paste provisions. So one may say these, maybe they didn't really think too much about it. But what I notice is that the countries that have signed these agreements are not countries that we will consider as having little legal knowledge. These are countries that have the lawyers, they know what they're doing. So for me, from a certain perspective, it's true that maybe they have copy and pasted, but not every agreement that has been signed after 2020 includes an AI provision. So the absence of this provision in certain agreements maybe tells us more than the actual inclusion of the agreement in these countries. Now, what are the second question that I had for myself was, what are the factors that may influence this diffusion? So can we see, for the moment, we see that neither of them is really diffusing a lot. The data are still relatively limited. But what we can argue is that there are certain factors that we need to think when in evaluating whether one of these models can actually prevail over the other. One factor is definitely time. It seems to me that it might be easier for the Singapore model, so much more this soft law approach, to develop at least in the short term. Because even after the European Union had proposed and had adopted the UAI Act, there is already a lot of talk about suspending the application of the regulation. There are concerns that maybe the European jumped the gun a little bit in regulating AI, and therefore a lot of countries may feel like maybe we need to take a step back and take it slowly. Other aspects, endogenous factors. What makes the European Union approach interesting? Well, one of the strengths is that it is binding, it is enforceable. So for example, for companies, it can be a good thing to have the certainty that comes from really clear regulations, and the fact that it's no longer a patchwork of regulations that change depending on the sector, on the issue, but it's harmonized rules. But the problem is with enforcement, you need enforcement capacity, and not every country may have that enforcement capacity to do so. The second issue is AI capabilities. There are differences in AI capabilities among countries. It is more likely that countries with high AI capabilities, and we see this, Japan, South Korea, even China, may follow into the footsteps of the European Union because they may have the knowledge, the understanding, they know how to gather the information necessary to negotiate such a complicated type of regulation. But countries that maybe fall behind, what we will say, the countries that are more find the digital divide more challenging, they may struggle to actually being able to negotiate such a regulation. And clearly this goes together also with another element, the institutional setting. Some countries are able to quickly develop their legislative processes quicker, maybe it involves more stakeholders. For others, it can be way more complicated. And therefore, maybe the EU system is less appealing to these countries than the soft law approach proposed by Singapore. And clearly also trade dependent. Is a country, how trade dependent is a country? One of the key differences between the European Union and Singapore is that the European Union is a massive market of 500 million consumers. Singapore is a tinier country that is very much trade dependent. So while the argument about Brussels effect is based also on the market side, the relative power that the European Union has, and still it struggles in that sense, Singapore cannot afford to adopt regulation that will scare off businesses from doing business in Singapore. So this might explain why Singapore went for a more soft law approach. And this might explain why other countries that share similar characteristics with Singapore may find that approach way more attractive. last couple of points that I want to make is clearly we need also to understand the geopolitical context when we are operating. So there may be also exogenous factors that influence whether countries would go for a more comprehensive and binding regulation as opposed to soft law. The third question that I had for myself is, okay, this said, having seen sort of this little empirical data, what's next? Well, this is very much still a work in progress type of research. So I haven't really been able to find an answer to this question. But one of the things that I'm thinking about is whether we can maybe find a type of regulation that combines, in a way, the hard model and the soft model. So try to say, maybe we can have some more binding regulation, because the soft law doesn't necessarily respond to the needs that arise from some of the challenges posed by AI, but maybe going the way that the European Union went, maybe a little bit too taxing on companies and may have a very detrimental effect on international trade. So maybe the way forward is maybe to think about some sort of a hybrid approach. So thank you very much. And I'm very much open to questions. Thank you.
Okay, thanks for three of our speakers, and I like to invite our speakers sit on stage. And we are now open for the questions from the audience. Okay. Please can share your name with us and tell the questions who you're directed to. Thank you.
Okay, thank you for this wonderful panel. I'm Shota Watanabe, working for a Japanese think tank and advising Japanese government regarding digital trade and AI regulation separately, not combining them. So I have one comment and one question to Dr. Soprana. One comment is that, so actually Japanese, a new AI law has an extraterritorial effect to the advanced models like ChatGPT, and they have a kind of investigation authority for the Japanese authority, and actually they are now launching their investigation maybe very recently, because the people say they have, have some kind of preparation for the possible damages like discrimination or sexual exploitation or something like that. So that's a one comment. And actually, my question is that, yes, you explained the difference between Singaporean approach and EU approach based on the size of the market. But I think with respect to Japan, we think about the both approaches, and our conclusion is that under current market situation, there's no need to more strengthened approach like EU. So we need to kind of investigative power to once some incident occurs, but we secure more wait and see approach to having to reserve more discretion for the companies to really develop the AI services. So I think we need to more delve into the causes of the approaches. That's my question.
Do you want to collect maybe, because it might be.
Yeah, so my name is Francisco. So I have one, I don't know if I can ask two questions, one general question and another one. So my general question to all of you is if you envisage that the AI framework could get stopped at some point in terms of legislative proposal. So what I'm thinking is not only in terms of the usual one, which I think is the most clear one. It is the AI and IP. So, but rather I'm talking about a very concrete WTO case, which is the electronic transmission, the moratorium. Because in the last ministerial conference in Abu Dhabi, several members said that it was going to be the last time that over the dead body, they were going to allow this to happen next time. And I think if tariffs are going to happen on electronic transmission, this is out of the way, first of all. So AI will be quite limited, quite impacted. The second, another regulatory constraint that I see is the IP. That I think I will touch with Professor later. And the third one, which I think, I don't know if you consider, is the technological divide, because AI requires lots of energy. So for certain countries, they simply cannot afford having AI because they don't have access to energy. So I don't know if you see, especially I'm very interested in the electronic moratorium one, because my perception is that it's going to be a very difficult battle in the next ministerial, because countries are searching for sources of revenue, and that is one. So that is my general question. And then to the second, to Professor. I ran out of battery. Too intense, too intense. Yeah, now it works. So my question is on IP. So I work in the integrity division. So this is that disclaimer in the secretariat. So probably I'm not most objective. Change? Or you can just. So nobody's online. Your choice. Microphone. Excellent. Yeah, so I think it was interesting, your paradox thing, because I think we are living a Lampedusian moment. So everything must change, so everything remains the same, really. Because I always think that we should bring academics to the, discussions in Geneva. Because I can assure you, if we were able to broadcast any of the WTO committees, you will be shocked. Because members, delegates, diplomats do not want to change a single comma of the agenda, let alone of the agreements. So I share with you that perception that the system obviously is 30 years old. I mean, of course, it requires reform, I mean, by all means. But to me, and this is more about the IP question on AI, I have serious doubts that not so much about the output, but the input is not a breach of copyright. Because I think that the model training that requires so much data, at some point there is a copyright violation there. I mean, it still needs to be found out by courts and whether the legislators are going to be that. But the data mining issue, already the EU is legislating, the UK is about to introduce the similar legislation in the UK. So I wanted to know your opinion, and also a very important subject I think IP scholars in particular are leaving behind is how to connect AI to licensing. Because the moment you can get licensing of the inventions, I think the AI will change, because of course, then it will be an innovator. Because I'm thinking a lot about copyright. Because in the terms of patents, I think it will be very difficult to claim that the AI has done the innovation on its own. So, I mean, I wanted to know your opinion on that, and if you could express on the output input in the LLM. So thank you.
Thank you. Mine is very short, and Francisca, and would like to echo almost everything what Francisco said, and that's why not repeat. So specifically to the moratorium question, we had that in the session this morning already, so that's why not repeat. But directly to Rostam, you said at the end, so time is obviously coming also from Colin's papers and your collaboration. You ended with time was not addressed in the same way. So what is your suggestion? You mentioned the two proposals that you rejected. So what is it that we should do? What are you saying?
One quick question to Marta. So I'm very interested in your comparison between the European Union and Singapore. I think you somehow expect that there could be a lot of reservation about this comparison because it's a little bit like an apple to orange comparison. So you mentioned like 4 or 5 dimensions of possible interpretation, but I do want to add one more. So I think you should also take into account the difference in legal origin between these two jurisdictions, civil law versus common law. For civil law, it's fine to have it's nice to have statutes, enforceable legal obligations, bright line rules, while in the case of common law, principle-based, something very high level, but we can always look for additional guidance or unwritten documents so as to enforce the rules. And I think Singapore might belong to that camp. When we study Singaporean laws, you cannot just look at the guidance. It will always look good. But you definitely need to check the practice, especially some unwritten guidance imposed by the Singaporean government, because this is a relatively little economy. It is easier for them to communicate the real regulation between the regulated. So I think that could also add some hurdles to your comparison, but I enjoy listening to your presentation. Thank you.
Thank you. So I have 2 quick questions. My name is Nidia from Singapore Management University. And the first one is about the Singapore approach. So very thought-provoking, your presentation, Marta, but I was wondering if you took into consideration that the soft approach in Singapore is not as soft as it seems on the books. Because, for example, just to give you a concrete case, HSBC was investigated by the Data Protection Authority, which is the Data Protection Commission in Singapore, because of a breach of the Personal Data Protection Act. The case basically is about an AI system, and the bank used this to deny a credit card application, and they denied the client the right to know the outcome of the AI system, which was the credit score, basically. The commission said that they were in the right of denying this because an interpretation of the act, but they ended up evaluating whether the bank was actually complying with the model AI governance framework. And if you see companies in Singapore, it is soft law because there are no teeth on this type of guidance, but all major companies, all big companies are expected to comply with this. So I was wondering if you took into account this nuance about what Singapore considers soft, and that's a major cultural and maybe infrastructural difference between Singapore and other jurisdictions where soft law is actually soft law. And the other question was about the very thought-provoking as well presentation by Anthony on how other regimes can complement international trade law in terms of regulating AI. You mentioned competition law, but I was wondering if other regimes such as financial regulation or the Digital Services Act, the Digital Markets Act in the EU can also contribute in adding something in that space, given that they are, for example, talking about the third-party dependencies and this problem of major AI companies being the ones dominating the market share in the ecosystem. Thank you.
Okay, thank you so much. Amazing questions. I would like to thank in particular the people that offered the comments on my research. Thank you, because it really helps me sort of improve it. And I will start by saying about Japan, thank you so much. Unfortunately, I do not speak Japanese, so I have to rely on sources that are translated by others. What I found so far, and by the way, I'm aware that the law has literally just been approved. So it was, I think in May, I think it was approved. I haven't been able to find, I've been looking for a proper translated version of the law. So what I've read was some of the comments were that they were make some comparison and indicating that that law, at least compared to the other two, was more related to the domestic dimension and didn't have the same extraterritorial reach as the others. But by all means, if you have a translation in English that I can, or sources that I can use, please, by all means, I'm really open to read them because it will really help me understand better. With regards to the second point on the wait and see, sort of the Japanese approach, when I mentioned the comparison between the European Union and Singapore using sort of the market size, it was one of the differences between, because one other aspect, for example, that goes to your question is also cultural values. In Japan, as in Singapore, AI is seen way more positively than in the European Union. In the European Union, we have a very, oh my God, we're going to die approach. In Japan, I mean, Japan has been, even in the past, robotics, robots, the approach that Japan has is way more optimistic. We think in terms of Terminator, you think more in terms, it is helping, the elderly. And so I think that also is something definitely is one of the factors sort of that I consider. So, but I really appreciate sort of the comments, including the difference between the legal systems. Yes, I do think that there is also a difference in the institutions. The reason why I compared these two countries, that I agree with you, it's like apples and oranges, was because these are two countries that it seemed to me were the first to move into really going from trying to do something that was not just ethical principles, but trying to target specifically AI, but that it was relevant to trade. The European Union specifically because it bans certain AI systems. So it is clearly creating a barrier to trade. And I wrote an entire article on the compatibility of the UAE Act with GATS and TBT. But then for Singapore is the fact that they were the first, sort of the driving force behind the inclusion of that AI-specific article in international trade agreements. So I thought that was also the interesting part. Thank you so much about the part on the soft law approach. Thank you. I will look a little bit more into that. I do agree that there are sort of the fact that it's written as a guidelines doesn't mean that the expectation that you should actually really follow this exists. I absolutely agree with your point. I would be happy maybe to learn more about sort of, yeah, that would be great. One last point about sort of what Francisco, I think, raised. Going even to see the experience of the GSI that some of us discussed this morning, I have to say I'm generally a pessimistic person. I see sort of with the GSI, I saw that already really the provisions that had teeth were removed from the stabilized text. And I think that artificial intelligence now in particular, my personal opinion is the more this technology is seen as general purpose, the more it's seen as a national, like linked to national interests, national security, economic security, the less incentive governments have to sit down and restrain the policy space. So if that means that they're not going to negotiate rules to try to harmonize this patchwork of regulations that more likely are going to emerge, and again, the EU and Singapore are just two examples, but a lot is also happening in other countries. I think that it will make it a little bit more difficult for countries to arrive to common ground at the WTO. I'm sorry to end on this pessimistic note, but I'm trying to be honest. Okay.
Thank you very much. Well, thank you very much indeed. Too many interesting questions and not enough time. Just briefly, I think my main concern is that we are just, and that combines both questions, we're not learning from history. Like you said, Lampedusa, I think Hegel said the same. We only learn from history, that we never learn from it. And time is the key to me. The interesting thing is that's a different story in a way, but all paradoxes and oxymora seem to be like irresolvable until you consider a new dimension, and that new dimension is time. And that's what I try to show in a way that from culture industry, intellectual property, cultural property, AI now, virtual reality, all these are oxymora, and they all show the same challenges cognitively, and we are still coming up with the same old terms and notions, like, okay, now we call it tariffs on electronic submissions. And what struck me the most about IP law was that this was the IP and AI debate is limited exactly to these 2-3 questions. Is it considered theft, or is it fair use? And what do we do when AI invents something creative? Should we give it copyright status or even legal personality or something? These 3 questions. Nobody looked at, hardly anybody. There is a great book edited by Peter Yu, I think, from Hong Kong, Texas AM. They look at inequality, and not only north-south divide, inequality within and between professions. And that's where the challenge lies, in my view, in the future. Are we going to be remunerated fairly for whatever work we are going to do? And this is not a decision I want to see taken by those. Every now and then I get Bill Gates telling me in 10 years there will be no lawyers in my social media feed. But is he in fact legitimized to make that decision? I think we should take it together, and that's my main problem. We need to take these decisions together, and just time is the key element, I think, today. And there's a nice link also to technologies. I think oxymoron are the language side of change that is forced upon us, which we do not want to embrace. And technology is another. The technology manifests this thing. And the interesting thing is, I found an article about what is time, like from a physics perspective. I think it's called the unreality of time. And then nowadays, a lot of the AI Act in Article 5, for example, prohibits real-time biometric identification systems. And we are now living in a real-time environment. And I was wondering, what is really time, right? And that's why we need to look at that. But my next book will hopefully cover that. Thank you.
Yeah, thank you. Thank you for the question. I realize that this is just, talking about competition law is really just a delimitation of the research. When you're looking at the effect, this great impact of AI on international trade. So I am saying that over the long term, it's actually going to erode the power of border controls. The tariff is just one example of border controls, but it's going to be eroded because AI's nature is towards systems integration. And yes, the topic for further research should come up about how we regulate. So there'll be all kinds of regulations, especially for public interest, public health, public safety. And it will highlight the differences between jurisdictions in how well they're able to impose these regulations. Are the regulations too heavy-handed or too light? So there'll be, of course, it'll highlight the divide in the world with regard to regulation. But again, that's towards the evolution of either mutual recognition or harmonization of regulations. But you eventually, over the long term, have to accept and recognize that we are forming larger footprints, larger relevant markets. And within these relevant markets, similar to, let's say, established economic unions like the EU, you will have to have common standards and common regulations eventually. But that's something that probably is worth a few more dissertations. Thank you.
Okay, thank you so much. As we are coming to the end of our panel, I'd like to thank everyone here for your questions and your participation today. And I want to sincerely thank to our speakers for their sharing. I hope this conversation will continue and will inspire us to keep thinking about what kind of regulation we want to govern AI in the future. And please join me in giving them, our speakers, a warm round of applause. Thank you.